It's a debate that was interrupted, and the last time it was being debated, the Victims' Orders Against Violence Offenders Bill. Ian McKelvey had the call. If he doesn't seek to wish the call, the next call would be a New Zealand First call. Dennis O'Rourke.
Mr Speaker, this bill is one of a number of moves which have been long needed to improve the rights of victims and to support them when they've been subjected to violence. Fear and anxiety about unwanted contact with the offender can be as bad as the offence itself and can impair the recovery process of victims and their ability to enjoy a normal life. As introduced, the bill was something of a mess, I think, and needed substantial amendments. Most of those defects have now been fixed, but the bill is still not as good as it could have been. While New Zealand First will still vote for the bill because the improvement in victims' rights are an important part of New Zealand First's policy agenda, this should be regarded as a work in progress and as a bill that will need further work. It is legislation that will need further work by the next government. Clause 6 defines a violent offender as a person who, quote, has been convicted of a violent offence that affected the victim and has been sentenced to a term of imprisonment for 2 years or more. As introduced, the bill required sentencing to a period of 5 years or more, but the amended definition has been to conviction for 2 years or more, and that is now acceptable to New Zealand First. Otherwise, the scope of the bill would have been far too narrow and too many offenders would have escaped the net. But I still have some serious concerns about subsection 9(1). That subsection says, quote, the court may make a non-contact order if it is satisfied that A, there are ongoing effects of the offending for the victim, unquote. But why does the court have to be satisfied that there will be ongoing effects of the offending? What has that really got to do with it? What would the victim actually have to prove to satisfy that test? I don't believe that that's an appropriate test at all, and that subsection should have been deleted. Similarly, subsection 9(1)(b) should have been deleted too. It says that the court must also be satisfied that, quote, the possibility of contact between the victim and the violent offender will be detrimental to the victim's ability to manage those effects, unquote. It should not be necessary for the victim to have to prove that either. Subsections C and D of subsection 9(1) are by themselves sufficient. They provide that the order must be reasonably necessary to avoid contact, taking into account all of the circumstances of the case. We should simply leave it to the court to judge whether an order is reasonably necessary, taking all those circumstances into account. Because it is the possibility of unwanted contact that is the real issue, and that is the issue that the victim will be particularly concerned about. There should be no inquiry as to ongoing effects or the victim's ability to manage them. That is completely unnecessary and is a hurdle that a victim should not have to jump. In fact, it could be a disincentive to victims to have to produce that sort of evidence. It may be one of the things that stops them from using this legislation. So it's a shame that those additional tests are there. That's the only notable defect, however, in this bill, and it is something that I hope the new government will do something about. So New Zealand First won't oppose the bill for that reason. We're just rather disappointed in it and look forward to an amendment in the future. Clause 11 sets out the effect of a non-contact order, and that has now been amended to temporary non-contact order, with the effects of the final order being provided for in section 11A. An order prohibits an offender against whom an order is made from having any form of contact with the victim. And in addition, the court may prohibit the offender from entering, living in or working within a specified area. I have previously expressed a concern that it's necessary for us to make sure that that won't inhibit an offender from obtaining or maintaining their employment. But the new Section 11A has solved the problem, and the effects on a final order now have much more comprehensive and refined powers for the court to specify in relation to excluded areas for entry, residence and employment. So now the effects of the order will be no more than needed to properly protect the victim. That's an inquiry the court will have to make, and will need to make an appropriate order to balance the needs of the offender and the protection of the victim in that way. So because that's something that's now been achieved in the latest amendments, New Zealand First can welcome Section 11A and also the new Section 11B, and that deals with the need for a final order to be directed by the court to apply to specified other persons who the offender may encourage to engage in the contact behaviour which the offender might engage in. So, Mr Speaker, overall, although the bill doesn't include all that New Zealand First wanted, and there are some serious defects in it still, it does most of what New Zealand First would have sought. So it's a positive step forward for victims, although it is a work in progress, and a new government this year will provide an opportunity to move ahead still further in the protection of victims' rights by having another look at this legislation. I note that the Sensible Sentencing Trust is promoting the appointment of a Victims Commissioner, as has been done, I believe, in the United Kingdom, and that may not be needed. And it will depend rather on whether the departments and agencies involved actually now develop a better culture towards victims' rights, because of course the legislation can't achieve the objective by itself. So we're going to rely on the people who work in the area in those departments and agencies to adopt a more supportive culture in terms of victims' rights. So we can wait and see whether they achieve that. If they don't, we can look further at the need to appoint a commissioner, as proposed by the Sensible Sentencing Trust. But it may not be needed, and I hope that it is not needed, because I believe that there is a good possibility that the culture that I spoke of will change as a result of this legislation. So for all of those reasons, Mr Speaker, New Zealand First will be voting for the bill.
Jackie Dean.
Mr Speaker, the following scenario